Okay, hi everybody. Welcome to week 9. Time for the long-promised and long-awaited video on the civil rights cases. Those being the cases involving the constitutionality of the civil rights laws of 1964. Those laws have been in the news again because of the recent LGBT case. The cases are Heart of Atlanta Motel on page 103 and Katzenback versus McClung on page 104. One obviously involving a motel, Katzenback versus McClung involving something called Ollie's Barbecue, right, a small eating joint. These racist institutions, organizations, businesses didn't want to go along with the civil rights laws. Now, a little background. Congress had tried in the 1800s to enact civil rights legislation, and in doing so, cited the 14th Amendment Equal Protection Clause and its authority, Congress's authority under Section 5 of the 14th Amendment. If you, well, we'll talk more about that, but here's the basic structure of it. The 14th Amendment says that no state is allowed to deny equal protection of the laws. So let me repeat that. No state is allowed to deny equal protection of the laws to any person within the state's jurisdiction. The 14th Amendment was a post-Civil War amendment, so it makes sense that the amendment would target states. After all, it was states, right, that caused the Civil War. Contrary to probably popular belief, the equality principle did not show up in the Constitution until 1868 with the adoption of the 14th Amendment. The Constitution, as originally drafted, the original articles of the Constitution do not have, or the Bill of Rights for that matter, do not incorporate the idea of equal protection or equal treatment. In fact, the original Constitution has the 3/5 rule built into it, so it was inherently unequal. And again, racist. So, along comes the 14th Amendment. Finally, in 1868, we have a provision in the Constitution that requires equal treatment, but it requires that of the states. Remember this, because we're going to talk about it more at the end of this term. The audience for the Constitution is the government. The Constitution creates, empowers, and limits government, what a government can do. So, think of the Constitution as a big old speed limit, and it's facing the government. It's the government's speed limit, not us as individuals. This is all going somewhere, okay? So the 14th Amendment requires that states provide equal protection, or at least that they not deny equal protection of the laws to any person within their jurisdiction. Section 5 of the 14th Amendment, so that's the Equal Protection Clause is in the first part of the 14th Amendment. Section 5 of the 14th Amendment gives Congress the power to enforce the 14th Amendment, which means to enforce the Equal Protection Clause. So when Congress first tried to enact civil rights legislation, it did so and said it was doing so under Section 5 of the 14th Amendment. Okay, the Supreme Court struck down Congress's first try at civil rights laws, saying that the 14th Amendment, right, the Equal Protection Clause only targets state action, and that Congress, and see, the civil rights laws are not directed to just the government. The civil rights laws are directed to private parties, right, that are running businesses, mostly businesses involving quote-unquote public accommodation, restaurants, theaters, things like that, places that are open, generally speaking, to the public. And what the court said in those original civil rights cases was that Congress couldn't reach private conduct through Section 5 of the 14th Amendment, because Section 5 of the 14th Amendment only authorizes Congress to enforce the Equal Protection Clause, and the Equal Protection Clause only applies to states. Okay, sounds like an LSAT question. So that's some historical backdrop to where we are. Okay, so decades go by. When the 1960s roll around, after Brown versus Board of Education in 1954, the 1960s coming up, you're all aware of that. That's fairly recent history. Things were getting a little bit more progressive, and Democrats in particular under John F. Kennedy and then Lyndon Johnson, wanted to enact civil rights legislation again. But now they had figured out what part of the Constitution, think about this, right? Now they had figured out what part of the Constitution was the broadest power they had. So they were not able to enact civil rights laws under Section 5 of the 14th Amendment, but now for decades they've been pretty much been able to regulate whatever they want, as long as they put it under their commerce power, right? As long as they regulate under their commerce power rather than through some other part of the Constitution. You'll recall that in the 50s and 60s, the court takes a very broad view of what Congress has the power to do under the Commerce Clause. So they smartened up and said, oh, if we want to pass civil rights laws, maybe there is a way to do this after all. Now, I want to show you a video clip. And the video clip is something that, well, first of all, let me set this up. It's John F. Kennedy. John F. Kennedy was known for his press conferences. John F. Kennedy had a very quick wit, was known to be quite funny. And so his press conferences were sort of must-see TV at the time. He was holding a press conference, and a reporter asked him, a reporter who appears to have had racist instincts, asked him, these civil rights laws, because keep in mind, Kennedy wanted to pass the civil rights laws, right? That was his thing. He was obviously assassinated in 1963. And Lyndon Johnson took over, and Lyndon Johnson then became the president who presided over that. But Kennedy started the ball rolling. So a reporter asked Kennedy, what about somebody who owns a small boarding house? Are you going to force that person to allow somebody into their home or their boarding house whom they do not want? Now, the question that JFK the answer rather that JFK gave would not be understandable to anybody who didn't understand what we're talking about right now in constitutional law. But there were people in the room who did understand it. It took a minute after he answered the question. You'll see it, that a few seconds after he answered the question for it to sink into people. And then some people in the room burst into laughter because they realized that this person who asked the question had just been schooled. And so, so I'll show you the video clip and then ask you why.
I don't recommend it to others, at least for a while.
President, do you think that Mrs. Murphy should have to take into her home a lodger whom she does not want, regardless of her reason, or would you accept a change in the Civil Rights Bill to accept small boarding houses like Mrs. Murphy?
The question would be, it seems to me, Miss Gregg, whether Mrs. Murphy had a substantial impact on interstate commerce.
All right, so what just happened there? He gave away, right? And so again, the people in the audience who understood this stuff knew what he was saying. I'm sure there were people in the audience who did not know what he was saying. But he gave away how he was going to try to pass civil rights laws this time, right? By linking it to interstate commerce, and in particular, the substantial effects test, right? So a pretty smart guy, knew what he was talking about. He said, if this activity, racism in interstate commerce, has a significant impact on interstate commerce, then yes, the answer is yes. This can be regulated, and it will be regulated. Okay, fast forward to 1964. Here we are, again on page 103. Imagine for a moment that you're the lawyer for Heart of Atlanta Motel. I mean, I'm not suggesting anybody should want to be, because that's again the racist motel. But just to kind of get in the mindset of how fast this case went south on these lawyers. If you're the lawyer for Heart of Atlanta Motel, so you're the one arguing that Congress has no authority to regulate racist exclusions, right, for owners of public accommodations. And you know, of course, because you've been through the arguments, that the government is now arguing that it had the authority to pass civil rights laws, which bans people who operate public accommodations from discriminating on the basis of ethnicity. That the government is arguing that they have the authority to do that under the Commerce Clause. Right, Congress's authority to regulate interstate commerce. And you begin reading the case, and the very first thing the court talks about, Heart of Atlanta near interstate highways. If you're the lawyer for Heart of Atlanta Motel, and the first thing, right, this is bracketed, right, the summary, but the first thing the court starts talking about is how close the motel is to interstate highways. 75% of its guests from other states. Okay, so I mean, at this point, if you're the lawyer for Heart of Atlanta, you can pretty much stop reading. There's absolutely no reason for the court to start with this, right, this discussion of interstate highways and interstate guests, unless it's obviously going to say that Congress has the authority to reach this activity under the Interstate Commerce Clause. Ollie's Barbecue case starts pretty much the same way. If you're the lawyer for Ollie's Barbecue, and you start reading, and it says, Ollie's Barbecue, a Birmingham restaurant, 11 blocks from an interstate highway. Well, there you have it, okay? Bottom line, the Supreme Court upheld Congress's authority to enact civil rights laws under the Commerce Clause, even if it did not have that authority under Section 5 of the 14th Amendment. The important thing to note when you're talking about the factors under substantial effects test, because let's run through this, we can run through both at the same time. If this was a modern day analysis or an exam question, right, what would you do? You'd say, okay, racism, discrimination, right, in places of public accommodation, is that regulable under the Commerce Clause? So you do the whole Article 1, Section 8, expressio unius thing, you get all that out of the way. You identify now the Commerce Clause as the clause that is in play in the case. You then delineate, right, your categories and say the categories that can be regulated by Congress include channels, instrumentalities, and substantial effects, activities that substantially affect interstate commerce. Is racial discrimination, and again, please be precise about this. Is racial discrimination a channel of commerce? The answer is no, okay? It's not a highway or an airway or whatever, okay? Is racial discrimination in public accommodations, is that an instrumentality of commerce? Of course it's not. It's not a boat or a truck, right? You only bring up channels or instrumentalities when that's the actual thing being regulated. And it's not being regulated in this case. Therefore, racial discrimination in public accommodations would have to be an activity, right, that substantially affects interstate commerce, and that's what JFK was saying in that clip. So acknowledging that's what we're talking about. Okay, so then you'd run through your 4 factors. Is it economic? Well, in a sense, it certainly is. I mean, hello, Wayne. Nice. Okay, good girl. Right, because the thing, what's banned under the law is not private discrimination or private racism. That, frankly, just can't be regulated by the government. What's regulated is, what I mean by that is in private interactions just among people in their private lives, right? What it regulates is, right, people discriminating in the provision, right, get this, in the provision of public accommodations. So refusing to rent a room, refusing to sell food, right, that kind of thing, refusing to sell a ticket. So obviously there's a very plausible argument here that this is economic activity that's being regulated. It's not non-economic activity. Yes, it involves something that's immoral, but only in a commercial or economic setting. Is there a jurisdictional element? No, there's no jurisdictional element. You know how that works. Doesn't really matter. I mean, I shouldn't say that. It matters, but it's only a factor, right? So it's not outcome determinative. Here's the part you really want to take away. These cases are most often cited for that third factor under the Lopez-Morrison structure these days, and that is hearings. We've talked about this in a live session, so I won't belabor this. Congress held extensive hearings, called many witnesses, and developed an extensive record of racism and ethnicity-based discrimination and its impact on business and travel and interstate commerce. And we mentioned the Green Book, right? Congress even unearthed a guidebook that African American families used and African Americans used to tell them where, if they were going to travel somewhere, they could stop and get something to eat or stop and get lodging, the very limited places where they could do that. Many witnesses testified that they would not travel because of the dearth of available places to travel interstate, the dearth of available places where they could eat or get lodging. So Congress here did its homework, right? It dotted its I's, crossed its T's, made its hearings, had its hearings, made its findings, and tied those findings to interstate commerce. They were not asking questions about the moral component, right, of racial discrimination. They were asking questions about its impact on the economy, on travel, on interstate commerce. Now, when it comes to attenuation, because the law regulates economic activity, again, you don't see all this analysis in here because this is the modern analysis. As far as attenuation, because the activity is economic, you can aggregate. Please remember that. So if all owners of public accommodations in the country are discriminating on the basis of ethnicity, then an entire part, right, an entire subgroup of the American population is taken out of interstate commerce, right? I mean, if everybody, who owns a restaurant or a motel in the United States or a theater is allowed to discriminate on the basis of ethnicity, does that have a direct and substantial impact? Would that have a direct and substantial impact? It did have a direct and substantial impact, and of course it would. So the court has no problem in these cases saying, yep, again, even if Congress didn't have this authority under Section 5 of the 14th Amendment, it does have this authority under the Commerce Clause. So the court upholds the civil rights laws, and in 1964, Congress was able to do what it was not able to do in the 1800s. Okay, so that's a brief description of the civil rights cases under the Commerce Clause. We'll be back to start talking about Congress's power to tax and spend. Until then, stay safe and stay tuned.